tied up matter made of 2020 matter. And earlier 29 2021 this case was listed before your worship, and the time was around after Diwali, and thereafter it has come to
yes, let's
2020.
Tomorrow if tied up, yes. Let it be called up. Yes. On the list.
From Delhi causes under the heading orders with defect, serial number 1, BA number 2134 of 22, Ms. Jaswinder Majumdar for the petitioner.
GR number mentioned in para 1 and prayer may be verified. The same is neither appearing in the FIR nor in the scheme order. Name of petition number 3 appears to be different, differs at institution and Kabbalah. Just two other differences.
Yes. Who has been granted bail?
Yes, Your Lordship.
Who has been granted bail?
No, Your Lordship, nobody. Yesterday, Your Lordship is pleased to call for the case study in one of the co-witnesses. 19 PA number 1929 up to 2000.
Yesterday.
Yes.
Call for the CD. Sorry. List this case along with
PA number 1929 of 2022.
BA number 1929 of 1022.
2022. Although other two co-witnesses have been granted bail, I have annexed that.
Serial number 2, BA number 2135 of 22, Mr. A.K. Chaturvedi for the petitioner.
What is the material? What is the material?
The cultivation.
Cultivation. Call for the case diary. Full stop. The state will file an affidavit intimating this court as to whether the petitioner is involved in any other similar nature of offence or not.
Serial number 3, BA number 2137 of 22, Mr. Sudhanshu Kumar for the petitioner.
In this case, madam, FIR lodged on 18/10/2021, madam, and PIC has conducted on 11/1/2022 after lapse of 2 months, madam. I annexed the serial list, madam.
He has identified you.
Yes, madam. After lapse of 2 months, he had identified.
Aadhaar card of the informant has
Seized for the
I
purpose of
annexed the
this
serial
petition.
list, madam, also. Kindly turn to annexure 2, madam.
Yes.
Page 70, madam.
Yes.
जब सामानों का विवरण चश्मा का एक डिब्बा सहित ब्लूटूथ एयरड्रॉप हेडफोन आधार कार्ड में कार्तिक प्रसाद राय, उसके बाद सेकंड पेज 80 में वाला सफाई करने वाला हैंडल ग्लास शर्ट का कपड़ा जिससे न्यूज़पेपर प्रिंट किया हुआ है, सेल्फ यूज मैच एक जोड़ी जूता सच एंड सच.
Who is the informant?
Kartik Prasad Rai is the informant lordship and his Aadhaar card has been recorded from the possession of.
I also stated in paragraph 11, petitioner has no criminal record and petitioner in judicial custody 6/11/2021.
Other Aadhaar card was recovered from your possession.
Yes, sir.
Heard the counsel for the not now.
My
Heard
lord,
the
one
counsel
thing,
for
one thing more, my lord.
Yes.
I stated in paragraph 10, my lord. FIR lodged on 18/10/2021, my lord.
Yes.
After lapse of 2 months, the TIP was conducted 11/1/2021, my lord.
Heard the counsel for the petitioner, heard the counsel for the state. The petitioner is an accused for allegedly committing an offence under section 392, 411 of the Indian Penal Code.
Yes, sir.
Full stop. Learned counsel for the petitioner expired. Learned counsel for the petitioner submits the case is absolutely false. First of all, he submits that the TIP was conducted after 2 months from the date of arrest. He submits that the petitioner has got no criminal antecedent and is in custody since 16/11/2021. 6/11/2021. Next paragraph. After going through the imputed order, I find that the petitioner has been identified in the TIP. Full stop. Even if the TIP was as one of the miscreants. Full stop. Even if the TIP was held after 2 months, but from the Caesar list and the imputed order, it is quite clear that the Aadhaar card of the informant, which was looted, was found from the possession of this petitioner. Full stop. Considering the aforesaid fact, at this stage I am not inclined to grant bail to the petitioner. Dismissed. Petitioner may renew his prayer after examination of the informant.
Okay.
Serial number 4, BA number 2138 of 22, Mr. Arvind Kumar Chaudhary.
Matter needs to silence, right?
Case diary, call for the case diary and the antecedent report of this petitioner.
Serial number 5, BA number 2139 of 22, Mr. Pranab Pranay.
So the case is under section 307 Arms Act and 17 CM. What happened in this case?
Petitioner name and alias name of petitioner at Wakalatnama differs from Muslim law. Parentage of petitioner is not stated at Wakalatnama.
Wakalatnama. I
Village name
in
is
course
also not
of
stated and post office is also not stated. The petitioner at Wakalatnama.
in course of the
Yes, what is the defect? The defect in respect of the Wakalatnama should be cured during the course of the day. Yes.
May I, Lordship? The case is, Lordship, there was encounter between police party and member of extremist, Lordship. And Lordship, one person was apprehended in the spot, namely Tutu Das, Lordship. And his confession, my name has come, Lordship. And he has been granted with also, Lordship, the other co-accused, Annexure 3, page 33.
You are in custody since when?
Lordship, I am custody since then, Lordship, and out of 11 witnesses, Lordship, 7 witnesses have been examined. I have annexed entire witnesses. They have not identified. They have stated that this petitioner is not identified by the police personnel, Lordship. And
How many examined witnessed?
11 witnesses, 7 have been. I have annexed all the
Out of 12, 7 examined.
7 on 19. Last witness is examined 2019.
And now tell me, you are in custody since?
Since Lordship 11/10/2014, Lordship. And several accused persons have been on confession, nothing else.
2010-2014 was demanded.
Nothing confession.
Out of 12 lots, 7 has been examined, and as per the June case study.
More than 7.5 years, 7 years, 7.5 is that? The petitioner is in custody for more than 7 years and the trial has not yet concluded. Next paragraph. The petitioner is an accused for allegedly committing an offence under section so and so. Full stop. After an encounter with the police and terrorists, next paragraph here. One of the terrorists was arrested. Full stop. The arrested terrorist, Chotu Das, disclosed that this petitioner was one of his associates. Full stop. Next paragraph. The petitioner has been remanded on 2010-2014 and since then he is in custody. And only 7 witnesses out of 12 has been examined. Further, several co-accused has been granted bail by coordinate benches of this court, whose case is similar to that of the petitioner. Considering the period of custody and the fact that trial has not yet concluded, I am inclined to release this petitioner 10,000 securities.
Serial number 6, VA number 214022.
But the allegations
Mr. Yogesh Modi.
the allegations are under 342, 323, 379, 504, and 8 Foxtrot and 63 RW I of SCSTS. Notes earlier an affair was lost. Notes the petition was granted bail by the court below.
Case type in Annexure 1 and impugn order mentioned differently. Means its correctness is para 1 and prayer para may be verified accordingly. Certificate of copying the department is also not appealing action. Plus clear.
These are related to STSC.
Now it's in the Foxo court. I have stated in paragraph 2 that earlier, now it's Foxo.
Cognizance taken under section?
Notes I have stated in paragraph number 1. Cognizance taken under section 452, 323, 379, 504 IPC, section 8 Foxo Act, section 3 RW Roman 1 of SCST Act, Prevention of Atrocities Act.
So the cognizance is taken under STSC Act, how this?
No,
bill is pending?
now, addition has come from this honorable court that in the case of Foxo and SCSC case,
Yes.
the case will be tried before the Foxo court. Earlier I have moved, in STSC case, while it was STSC case, it was withdrawn. I have stated in paragraph number 2 the details. I have stated not. Then liberty was given to move in the and the petitioner had earlier moved this honorable court for grant of regular bail in this case in criminal appeals, but the same was withdrawn with the permission and court by the honorable
STSC?
हाँ
No provision.
आज ये केस पॉक्सो कोर्ट में ट्रांसफर हुआ है.
Question is, a particular court may hear this, but what the law says?
Now let's see the case is.
The case says the case is also under the STSC Act. So, there's a provision of appeal most probably. There's a provision of appeal.
Then, not section. Yes, I have moved this court in appeal itself, Lords. Then not the appellate court not granted me permission to withdraw to file bail under the POXO. Not section 54 of the POXO Act. Not
Yes, neither POXO.
इसी में डिसाइड हुआ इशू में कि
क्या हुआ?
पॉक्सो कोर्ट पॉक्सो अच्छा वो तो हम लेके नहीं है कि
क्या वो व्हाट इज द डिसीजन?
बस एग्जैक्ट तो उसको नहीं बता पाते लेकिन यहाँ डिसाइड इसलिए उसको विड्रॉ भी करना पड़ा है मिस्टेक इन पैराग्राफ नंबर 2 itself नोट्स इट वाज
which provision you are relying upon?
सेक्शन 54 पर तो ऐड पूरा ना वो लग गया था इसे देखिए
कब का 2019? Yes, read that.
Yes. It was decided by Honorable Patna High Court not in criminal miscellaneous number 52792 of 2019.
Yes, what has been held?
It was held that the powers of Foxtrot prevail over the SCST Act.
By virtue of?
Yes,
Yes.
but there is under section 52 or 54 of the POXO Act, there is
नया वाला लाइए.
whether
नया वाला लाइए.
52 or 54, yeah.
Yes, it has been.
Already effective of the other offences are concerned, 52 or 54 of the Act, yeah.
And section 20 of the STSC says that overriding effect.
That has been dealt in this judgment.
That has been dealt with.
Section 20 of the SCST Act, you know, overriding effect is very high, you know. And that is dealt in this case, you know, I mean.
ये है जजमेंट का नाम है बुद्धू कुमार यादव वर्सेस स्टेट ऑफ बिहार.
So what is the give the case number and take a printout. Let us see. So POXO will have an overriding effect. It has been had. So what is the provision of the POXO?
Pardon, I could not follow the question.
What is the provision of POCSO? Which provision of POCSO you are relying upon?
इसको एक बार पासवर्ड करके हम यहाँ का एग्रीमेंट के साथ दोबारा देख सकते हैं यदि रिपोर्टिंग बात होगी.
Now, does POCSO say anything about the provision of bail? Does POCSO say anything special about provision of bail?
Provision of rape.
Bail. Tell me. Because STSC says that it will be an appeal.
Yes. It says
Now,
appeal.
if there is no inconsistency,
Yes.
then what will happen?
But since now the matter is being tried by POCSO as
So-
judgment, no plus kindly see one.
So cognizance has been taken under the
POCSO and
SCST.
Yes, both.
So POCSO is a special court.
Yes, both are special court.
Both are special court.
Yes.
Now, as per this judgment, the trial will be at the POCSO court.
Yes. So now there's one thing.
So the provision
now,
of-
now there's one thing. Notice.
Yes.
If the tribal court is a POCSO Act, and if there is no special provision that what will happen to the bail rejection order, then it should be treated as a regular bail like other cases.
Why?
And
Why not? Why not for the STSC?
because it is tried by the POCSO court. Because the court.
So tomorrow you will say the POCSO court will not have a power to punish you under the STSC Act.
No, I don't say.
Then?
The punishments brought under the POCSO Act are more deterrent than the STSC.
See, some what are the charges of POCSO? Over in this case,
Section 8 plus has been cognizance has been taken, though the offence is not made out of I will show from the act itself.
Section 8 only.
Yes.
And what is the STSC Act?
STSC 3R1.
So for the purpose, if I hold that no offence under the POCSO is made out, then the matter will go to the
No, case under POCSO Act is made out. It is
case
no-
under POCSO is made out, you are
Yes,
saying.
because the child is not a.
Bring the judgment, let's see.
Yes. It will pass away.
Password.
Serial number 7, BA number 2142 of 22, Mr. Avni Shankar.
Offences under section 354B, 376, 420, 468, 471 and 436 of the Indian. The date of occurrence is 10th of December 2017. The complaint has been lodged in the year 2021. The allegation
Date of allegation is of 2017.
The occurrence took place on 10th of December 2017. Rape was committed, and thereafter the petitioner assured the informant, who is a widow lady, that I will look after you and your children. And on the basis of her assurance, they lived together as husband and wife for 4 years. And when he did not perform marriage, the complaint has been, on the basis of the complaint, FIR has been registered. An agreement was also prepared between the parties, which is a part of the
Have you
FIR.
heard the counsel for the petitioner, heard the counsel for the state? The petitioner is an accused for allegedly committing an offence punishable under section so and so. Next para. The petitioner, it is a case that this petitioner has committed rape upon the victim informant, who is aged about 35 years. 39 years, and was full stop. It is alleged that the victim was widowed and having 5 children, and this petitioner assured that he will maintain her and will keep her. Full stop. It is alleged that this petitioner thereafter committed rape upon her and has also refused to marry her. Full stop. Next paragraph. From the FIR and the impugned order, I find that the occurrence of rape has taken place sometime in the month of December 2017. This case has been filed in the year 2021. What is the date? April 2021. The parties are major, aged about 39 years and 28 years. What is the major? Where the petitioner is aged about 28 years and the victim is 39 years. Now, full stop. Just because the petitioner did not marry the informant, this case has been lodged. Full stop. Considering the aforesaid facts, especially the age of the parties and much delay in lodging the FIR, I am inclined to release this petitioner.
Serial number 8, BA number 2143 of 22, Mr. Shashikant Thakur for the petitioner.
Under section 334 of the Act. Petitioner documenting the FIR name of the petition transferred on the basis of unreasonable statement of co-accused Sanatan Kisku. Petitioner statement has been annexed to page number 20. There is no direction in specific allegation against this petitioner. So only case of last suit.
Yes.
There is direct allegation against
Who has alleged?
my lord.
Who has alleged?
Both the lords. Between them and due to
Who has alleged? Who has alleged? You say that there is a direct allegation. I am asking you, who has alleged this?
Ram Alani.
Huh?
Allegation victim के मारा गया है पत्थर से.
I am asking you, who has alleged this? That this petitioner was also involved.
Sanatan Kisku.
So it is an allegation by a co-accused. 7 except this, there is nothing? Heard the counsel for the petitioner, heard the counsel for the state. The petitioner is an accused for allegedly committing an offence under section so and so. There is an allegation that this petitioner and another have assaulted the deceased and committed his murder. Next paragraph. From the impugned order, I find that the only material against the petitioner is the confessional statement of the co-accused, who confessed his guilt and implicated this petitioner, and stated that in the influence of liquor, the parties fought among themselves, and the accused, that is the co-accused, that is Sanatan Kisku and this petitioner, had given a stone blow on the forehead of the victim. First up. Next paragraph. The APP, though opposes but admits that 7 except the confessional statement, there is no material against the petitioner. Considering the fact that there is no other material 7 except the confessional statement of the co-accused, I am inclined to release this petitioner on bail 10,000 shillings.
Serial number 9, BA number 2144 of 22.
Registered under section cognizance has been taken, maybe that a lease taken is allowed. And plus the
What is the age?
18 years, this is for the 18 years and on the
Where is the statement?
assurance of
Statement.
is 12 months. On the assurance of marriage, one has established physical relationship with her parents. And thereafter, they also will get it at different place for some time or and then when he refused to survive the marriage, thereafter she has filed the case. So friendship was there till 2020, but he said that for the first time in the month of February 2021, he established the physical relationship with her.
The petitioner is an accused for allegedly committing an offence punishable under section so and so. I have heard the counsel for the parties and have gone through the impugned order and the FIR. In the FIR, the informant has stated her age to be 18 years. She states that she was in love with this petitioner and a physical relationship was established. She further stated that she had accompanied this petitioner to several places and when the petitioner and she became pregnant also. Full stop. She states that when she requested the petitioner to marry her, the petitioner refused. Full stop. Next paragraph. Considering the age of the victim, which is 18 years, and there was love affair, and knowing fully well about the consequence of developing physical relationship, establishing physical relationship, the relationship was established by the informant, I am inclined to release this petitioner.
Serial number 10, DA number 2146 of 22, Mr. Vinod Kumar Dubey.
Yes, and please committee matter. Nothing that is covered, no name, from the patient of the first victim of Guru Kumar, the petitioner have been litigated, instead Guru Kumar has to grant it. That is evident from the impugned order itself. And seven except the commission.
What was stolen? A vehicle was stolen.
Motorcycle was stolen. And the spy is found regarding the complicity of Guru Kumar.
A motorcycle was, petitioner is an accused for allegedly committing an offence under section so and so. A motorcycle was stolen. Full stop. Next, the petitioner is not named in the FIR. His name transferred from the confessional statement of the co-accused Guru Kumar, which is evident from the impugned order itself.
Page 18 and page 19.
Considering the fact that the name of the petitioner transpired from the confessional statement of the co-accused and he was not named in the FIR, I am inclined to release this petitioner 10,000 rupees.
Serial number 11, DA number 2147 of 22, Mr. Pramod Kumar Jha, for the petitioner.
Lawsuit is related to the cybercrime lawsuit.
Cybercrime.
Lawsuit.
CD, antecedent.
There's one case to 2291,
Take down. This case along with BA number
2091.
2091 of 2022, in which case diary has been called for. Full stop. Call for the antecedent report of this petitioner.
Serial number 12, DA number 2148 of 22.
Allegation is the order that brown sugar was recovered from her.
From the possession of this petitioner, brown sugar was recovered. First, counsel for the petitioner submits that the petitioner has been falsely implicated in this case and nothing has been recovered. She submits that the weight is only 17.4 grams, which is
below the commercial.
no, what is the
Brown.
small quantity,
5 grams.
which is not a commercial quantity. She further submits that the petitioner is a lady.
And she has no criminal.
And she has got no criminal antecedent. Next paragraph. After hearing the parties, I find from the impugned order in the FIR that 175 sachet of brown sugar was recovered from the possession of this petitioner, weighing 17.4 grams. Considering the material, which is brown sugar, and the quantity, and also the 175 number of sachets which the petitioner was possessing, I am not inclined to grant bail to the petitioner. Dismissed.
She is aged 60 years and she has no criminal antecedent. You all have stated that she sells the bangles here.
I don't know what she sells, but wait for some time. I will get the
Some
trial.
liberty may be given your
Liberty trial to be concluded at the earliest.
और केस में है दिक्कत मुझे शी इज एक्चुअली
Serial number 30, PA number 2149 of 22, Mr. Rajesh Kumar for the petitioner.
You may require the court case diary. Let me see whether I require it or not.
Yes, I am registered under section 307, 302, 120B of 34 of the
Name of the petitioner.
Name of the petitioner?
Name of the petitioner is Wakalatnama differs from his name.
What is your name?
My name is Sahil Khan, alias Sahil Khan.
Sahil.
Alias here from the include order
Alias name of
also.
petitioner missing at Wakalatnama.
Sahil Khan.
Alias name of petitioner missing at Wakalatnama.
Make necessary correction in the Wakalatnama during course of the day. Necessary corrections in the Wakalatnama by adding the alias name of the petitioner during course of the day. Yes.
Madam, case has been registered under section 307, 302, 120B and 34 of the petitioner. Petitioner is not named in the FIR. Madam, it has come in the include order that the petitioner, Madam,
Yes.
petitioner has been identified, but Madam, para 39 of the case diary has also been discussed. Madam, in para 39, the petitioner has not, the witness has not taken the name of this petitioner at para 39. So, Madam, only for this purpose, Madam, I am saying, Madam, this case diary because
Just a minute.
to verify. Para 39, Madam, it has been incorporated at page 19 of the include order.
You are Sahil.
Silence. And my lord, my client has also told me yesterday, my lord, that you want to engage some senior one. Para 39, my lord, this witness who has
What is the overt act of this petitioner? What is the overt act of this petitioner?
That has not been explained. You will not.
The overt act of Nesar,
yes, who has told
Nesar and others have been,
Nesar and
and Habibullah is there.
Yes.
But what is against this? Call for the case diary.
Yes.
Okay.
Serial number 40, PA number 2154 of 22, this calling will be Mr. Kishan Kumar Sahni.
The offense under section 379 for
379.
So, and certainly this was case of recovery of theft motorcycle.
From your position?
The petitioner is not named in the FIR, rather his son Shahjahan is named in the FIR as accused number 3. But one motorcycle was recovered from the house of the joint house of the petitioner and his son.
The petitioner is an accused for currently committing an offence under section 7 X para. It is alleged that one motorcycle which was stolen was recovered from the house of this petitioner. So this petitioner is in custody since
Since 29/12/2021.
29/12/2021. Full stop. Considering the period of custody, I am inclined to release this petitioner.
Serial number 50, PA number 2155 of 22, Mr. Arvind Kumar Sinha, Mr. Nirupama.
Just a minute.
Name of the petitioner at Wakalatnama differs from his name.
What is the recovery from him? Which are?
One country-made pistol with live cartridge, Your Lordship.
You are in custody since 5/21.
7/5/21.
The name of the petitioner be corrected in the Wakalatnama. There is some error typographical. Next paragraph. Counsel for the petitioner submits that the petitioner is in custody since 7/5/2021 for possessing a country-made pistol. So he submits the charge sheet has already been submitted in this case. APP opposes and submits that the petitioner is also an accused of Patrato PS case number 56 of 21 registered under section 392 of the IPC. Next paragraph. The counsel for the petitioner submits that counsel for the petitioner and reply submits that this present case is a offshoot of that earlier case. Full stop. Next, considering the fact that the petitioner is in custody since 7/5/2021 and charge sheet has already been submitted in this case, I am inclined to release the petitioner 10,002 rupees.
Serial number 16, BA number 2157 of 22, Mr. Rajesh Kumar for the petitioner.
Yes?
The petitioner has been instituted in the case registered under section 363, 365, 366A. Subsequently, 376.
Let's discuss with other one, POXO and STSC, both are there.
The law has Honorable Mr. Justice Kumar Chandri. That in the case of registered under section, registered under the provision of SCST and POXO, the PA will be defined. Also,
Where is the judgment? Where is the judgment? Now, if there is a conflict between two laws, then procedures, then you can say that which will apply. But if there is no conflict with the procedures, because these are the Self-Content Act which provides for the procedures also.
My lord, what has happened in that case, my lord? I have filed one criminal appeal. Subsequently, my lord, the court has directed me to withdraw the petition and file the BF I have filed earlier. Subsequently, court has directed to withdraw this application and file.
What is the law? Court directing you to withdraw the application, that will not establish the law. The law will be as.
Law, my lord.
What is the law? I am asking you. What is the law? Yes, Mr. Sarkar.
I'm just reviewing, my lord.
Both are special courts.
Yes.
Now, which act? Just a minute. Which act will have an overriding effect? Will depend upon the legislation. Both this court says that notwithstanding any other law.
Yes.
So the subsequent legislation is POXO. Now the question is, this
Sentencing power has
STSC.
to be seen, my lord. Sentencing power, because under the POSCO Act they can sentence up to life.
Life.
Whether under the SC/ST Act they are only that is one point that has to be.
No, that is for the purpose which court will hear,
Yes, ma'am.
but which procedure will be followed.
Yes.
This is my question.
Yes, my lord. Because POSCO is in warrant tribal case and this is SC/ST is a warrant tribal procedure
Yes.
that has been followed, my lord.
Yes.
Here this sentence tribal is being followed.
Yes.
So I, at least, my lord, at least to that extent the procedure which will be followed. That has
Which procedure? See, which court will hear, it is a different thing. But which procedure? And when there is no conflict of procedure, so what will happen?
Yes, my lord.
Your case, if it is STSC, the POSCO court will try STSC also and follow the procedure also. So then tomorrow, if he doesn't follow the procedure of POXO, he will say that the procedure has not been STSC, so entire trial is vitiated.
Yes, my lord.
So he has to follow the procedure. Now, if there is no conflict in the procedure, then why will you not file anticipatory bail your criminal appeal? Will this, was this thing considered in that judgment?
That has not been considered as per my.
Question is, it is not only the Mr. Counsel, the question is not who will hear. The question is which procedure will be followed.
For the purpose of granting bail by the Honorable Court, my lord, it is the law has been laid down. For the purpose of trial, it has not.
Why not?
No. There cannot be a law for
Yeah.
bail and there cannot be a separate law for trial.
No, there cannot be. There cannot be. This question has to be decided. It's not that superfluous. It may be heard by the POXO court because why
In camera proceeding and other things
why
are there
in
in
POXO? Because STSC Act, what is the maximum punishment in STSC Act? 7 or 10 maximum?
7 years.
7 years?
Yes.
So, the STSC court, I am saying the court which is hearing STSC. The court which is hearing STSC, he cannot punish for POSCO more than the 7 years. if he hears the matter.
Also, my lord, perhaps the section is 42 or 41, where the maximum punishment, suppose my lord, the in a court has been used to convict a person and sentence life to then my lord, the section 41 or 42 is there, which says my lord, the separate sentence is not required to be passed in also.
Separate, it's not, but I am saying about the STSC. If it is before the STSC court,
then to my lord 6 months to 7 years.
then he cannot pass any order more than that sentence.
Yes, my lord, and my lord, it is very surprising that a session judge has been passed this now. In the capacity of session judge, not the same capacity of a special court. This order has been passed.
How can that be?
Yes, my lord, may kindly have a look at the last page of the order.
No, because it was a.
My lord, as per my note, my lord, the ADG 1 has to be given as the power of the special court.
He has been given the power.
He's been given the power. He's been given the power.
Yes.
See, power of to deal with STSC cases is with whom? It is also before ADG 1. The POCSO is also before ADG 1. Now, so far as bail is concerned, there is a specific provision under the STSC Act.
Yes.
Read that. Read that. What is the specific provision?
14.
Section 14.
Yes.
Read that.
Appeals, 14A.
14A.
Notwithstanding anything contained in the Code of Criminal Procedure 1973 to 1974, an appeal shall lie from any judgment, sentence, or order not being.
So this is a special provision.
Yes.
Of STSC.
Yes.
Notwithstanding anything contained in the CRPC. So now, and what does the POSCO say about bail? There is no such. So this procedure will have an overriding effect on the POSCO or not? When there is no conflict? What has been held? What has been held?
But हम लोग का हाई कोर्ट जो हुआ है वो पटना हाई कोर्ट का और इलाहाबाद हाई कोर्ट का.
Bombay, what is Bombay held?
Under the court said that in case of special POCSO, court passes an order refusing bail to the accused booked under both the laws application under section 439 of the CRPC, which gives High Court special powers to grant bail, would alone be maintainable before the High Court, and the accused was not required to file an appeal under the SCST Act.
Give me all those judgments.
मतलब the our High Court मतलब the DA number 7931 of 2021. ये रिपोर्टेड नहीं
42A.
वही हम बोल रहे हैं. Madras High Court भी same चीज है. last but not least, second paragraph.
Come to section 42A of the POCSO.
It is a conflicting, then it will prevail, Mother,
42A says the provision of this act shall not be, shall be in addition to and not in derogation of. What does this word mean? Provision of this act shall be in addition to and not in derogation of the provision of any other law. What does this line mean?
If there is any law that.
This will be in addition, but not in derogation. What does this mean?
Later, neither part shall rely, Mother. If there is a conflict, then it will
Yes.
prevail, Mother.
Or
On that part,
line.
they are relying, Mother. Last part of.
In case of any
Inconsistency.
the provisions of the.
So the inconsistency is that here bail and here it will be 439. This is the inconsistency.
So it is saying that it will prevail under 42.
बॉम्बे वाला भी जो मुझे
Where is that Bombay?
BA number 817/2020 सूरज एस थंकर वर्सेस स्टेट ऑफ महाराष्ट्र इसको चेन्नई एक्ट को केस नंबर से मुझे सही होगा पेपर
पेपर का नहीं है ऑर्डर प्रॉपर ऑर्डर
You give the reference. There is no special provision for bail in this POCSO.
Yes.
In 20 of SCST Act is also there, that is the overriding.
That is the but But this is a later legislation. This is a later legislation. Subsequent legislation will prevail definitely. Now, what is the provision of bail? Most probably notice has to be issued.
Yes, ma'am.
Section 15.
14.
Section 15.
Yes, section 15. 15A.
Section
15. Also.
STST.
Obviously.
So if that be so, 15A. Where is that notice?
Just.
A5.
15 of the Act.
So POCSO doesn't say that notice has to be issued. So then why notice has to be issued? Tell me. The notice also should not be issued.
Under this Act, notice has to
So that-
be issued.
Not under this act. This act is having an overriding effect.
Yes.
So if you are saying that this act is having an overriding effect, the STSC Act will not be applied, provisions, then there is no question of issuing notice also. Whereas this says that notice has to be issued.
Act says that notice must be issued.
Then what will be? Tell me, answer this. Well, notice has to be issued or not?
Statute says, madam, under these provisions, CST, Prevention of Atrocities Act.
Prevention of Atrocities Act, notice has to be issued.
Yes.
But under the POCSO, there is no provision of
There is
notice.
no requirement.
Then tell me. Which one will prevail? Which one will prevail?
No overriding can't be come out.
Tell me.
Even Melody Division Bench of Madras High Court has also read Article 39 BA.
Now I am on the question of notice. On the point of notice, whether the accused, the victim has to be noticed or not.
Once Melody the BA application has been filed, the state is the party. Complete case, this is not the complete case, Melody. So right will not accrue upon the victim.
Just think of this line.
Yes.
POSCO, there is no notice.
Now, if POSCO will prevail, then obviously no notice needs to be.
Now the question is, both these legislations,
Yes, ma'am. Both are special.
special legislations for the benefit of the victims. Now a special benefit has been, so far as bail, this is only the forum.
Yes.
That you can say, it can be done away with. But the question is, when a special benefit has been given to the victim, whether that can be taken away by taking resort of POCSO. They're saying that it is POSCO doesn't say.
And one more thing, if an anticipatory bail is filed, then it is not maintainable. If there is POSCO and
Then it becomes maintainable.
then 89 there is a bar. See, this question has not been answered in any of the judgments. So that is bar.
So this has also not been raised here. In appropriate case, we can see it.
Yes.
Andhra Pradesh and
On that part, my lord,
the High Court, it has not been raised. Andhra.
Question is, all this act has to be seen from the perspective of the victim.
Actually, very initial
Because the
legislation-
legislation is very clear.
See, because it is the victim-based legislation, this
Yes.
special legislation. Now, when a victim has a right to be heard, this is a special right given to the victim. Forum is not a right.
No, for
And criminal appeal or directly before the criminal appeal before the High Court or
BA.
it hardly matters. It has got nothing to do with the victim. Yes, it's only a nomenclature and the jurisdiction.
Yes.
But so far as
Right
to be heard is concerned, can that be taken away, which a provision provides?
There is one rule, 413 and 414 and 415 of the POSCO rules, madam.
Yes.
Which provides that it is responsibility of the police to provide information about the status of investigation with regard to bail.
That is a different thing. I am saying this is a special provision where the victim has to be heard.
Yes, ma'am.
So now this
15A5,
special,
yes.
this 15A5,
A5.
can it be taken away
Because
by resorting to POXO? Take down. We have made the informant a party? The victims?
No.
Both the cases? Yes? We have made him a party? Have we made him a party? Since the provision of the case is also registered under the penal provision of the STSC Prevention of Atrocities Act of 1989, even though a regular bail is maintainable in terms of the judgment of several high courts including this court, notice in terms of section 15 capital A within bracket 5 of the STSC Prevention of Atrocities Act must be issued upon the victim. Full stop. Both these legislations, that is POXO and so and so, are a special act for the benefit of the victims. Full stop. Though the POXO Act will have an overriding effect on upon the scheduled STSC Prevention of Atrocities Act, yet this court feels that a special right which has been conferred upon the victim, that is the right to be heard, cannot under the STSC Prevention of Atrocities Act cannot be taken away by resorting to POXO, which doesn't provide the same provision. Full stop. Thus, this court feels that the informant be made a party in both these applications. In alag alag likhega. We made a party. Full stop. Next para, issue notice to the informant, registered ordinary, 2 weeks. Full stop. The parties are directed to make necessary corrections in the cost title and file requisites within a week. Within 2 weeks. Will not appear now. You are not appearing. Yes.
Serial number 6, Mr. Yogesh Modi, same order.
Same order.
Serial number 17.
Yes.
BA number
You want to say something?
informant appear.
वो deny करेंगे now is so I have to file a notice and I have to.
In earlier criminal appeal, I had appeared on behalf of the informant, but now you are.
No, this is a separate proceeding. Yes.
Item number 17, madam.
17.
Petition will be getting last time.
17.
Next week maybe. Take it back.
We are permitted to remove certain defects also.
In the meantime, the parties are will remove the defect. You were apprehended from where? You were apprehended from which place?
My lord. Counsel for prisoner is not.
How about the case area and the antecedent report?
Serial number 18, PA number 2159 of 22, Mr. Kaushik Sarkhe.
Section 392 murder petitioner is not named. Subsequently, the petitioner name transferred on the confession statement of Ajay Mandal.
Recovery?
No recovery.
TIP?
No TIP. Only confession murder and
Antecedent?
one antecedent. One antecedent is there and is in custody since 25/9/2021. No recovery, no TIP.
How the counsel for the petitioner, how the counsel for the state? The informant and his staff. Were looted on the point of revolver by unknown person. Next paragraph. The petitioner is in custody since 25/9/2021. He is not named in the FIR. Charge sheet has already been submitted in this case and there is no recovery from the possession of this petitioner. Next paragraph. Full stop. Next paragraph is same. The counsel for the petitioner, from the counsel for the petitioner, I get that the petition was never put on DIP also. The APP opposes and submits that there is one antecedent. One criminal antecedent. Considering the fact that the petitioner is in custody since 25/9/2021 and charge sheet has already been submitted and nothing has been recovered from his possession, I am inclined to release him on bail, 10,000 sureties, to appear before the trial court once a month, at least once a month.
Serial number 19, PA number 2160 of 22, Mr. Tarun Kumar, number 1 for the petitioner.
Office 449/34 IPC laws. On 4/1/2021 laws, all the 3 accused persons were apprehended by the police, and the 12-month coal was recovered from the 3 bullock carts.
What is the quantity?
12 months.
12 months. 12 months means?
1 month is equal to 40.
40 kg.
40. But it is quite surprising that they were apprehended by the police at the spot and the scissor list was prepared, but there is no signature of the petitioner in the scissor list. And it has come out in the last page of the review order. There is
480 kgs of coal was recovered from 3 bullock carts. It is alleged that the petitioners are involved in petitioner.
Petitioner of concurrent criminal history.
Yes, but it has come in the basis in also. One of the petitioner has been
3
apprehended by the
petitioners. It is alleged that these petitioners are involved in transporting and selling of mining, transporting and selling of illegally mined coal. Full stop. The petitioner are in custody since
4/1/2021 also. Sorry, 22.
4/1/2022.
Yes.
Only 2 months.
Only this. All are the old person also. They are located on 55-75 years. Only on the basis of suspicion they were apprehended.
Next paragraph. Considering the period of custody and the fact that the petitioner number 1 and 3 are aged about 65 years and 2 is aged about 74 years, I am inclined to release.
Serial number 20, PA number 2161 of 22, Mr. Kamdev Pandey.
This case number section 376 IPC. In this case, the trial has shown as a PW1 victim girl has examined, but she has totally denied the prosecution case. They can see the deposition of
Till the petitioner is an accused for allegedly committing an offence under section so and so. There is an allegation of commission of rape upon the victim who is aged about 17 years. Next paragraph. The counsel for the petitioner produces a copy of the deposition of the victim girl, which was recorded during trial, wherein the victim has denied the occurrence and stated that this petitioner has not done anything with her. The victim was later on declared hostile. Full stop. The APP, the aforesaid document is kept on record. Full stop. The APP opposes but cannot deny the fact that the victim has retracted from her statement as has been declared hostile. Considering the statement, 10,000 sureties.
Serial number 21, PA number 2162 of 22, Mr. Jayan Upadhyay.
Offense 498 and 494 husband.
494.
Yes, sir, 494.
What is the allegation?
Allegation like the
General allegation.
Yes, general allegation.
Custody since.
Custody since 22/8/21.
Petitioner is the husband as in his custody since 22/8/2021. First of the allegation is of demand of the allegation against him that he has demanded dowry, tortured his wife, and has solemnized second marriage. Full stop. The charge has been framed under 498 capital A and 94 of the IPC. Considering the period of custody and the fact the charge has already been framed, I am inclined to refuse this petitioner 10,000 to sureties.
Serial number 22, PA number 2163 of 22, Mr. Omkar Tiwari for the petitioner.
Yes, use this.
392 of the IPC.
Yes.
उनके पास से जो है ये उसी समय रिकवरी बात हुई थी लक्ष्मी और कल एक कोई कुछ का भी हुआ है. So far as this case is concerned, the date of criminal and and so far as giving no TIP is there and
You were apprehended from where?
from the Mandal hotel. All these persons were the casting the serial list is in page number 19. And all the accused persons were arrested from the same place.
Who has been granted bail?
The yesterday you are watching 27 Shubham Jha, 2023 of the
By this court?
by Congress. And in position of 2015
What is the number?
2023 of 2023.
2023. Just check it.
And custody is more than 20.
Yes,
The status shows it is allowed, but the order is not uploaded.
same order.
Serial number 23, PA number 2164 of 22, Mr. Mohammed Yasir Arafat.
Offense registered
400?
414 and transfer of the IPC not named in FIR. During the investigation, the petitioner is arrested.
Yes, APP?
Yes, Your Lordship.
Lordship, for the interview order, is one motorcycle and white
recovered from the possession of the petitioner. He has confessed the mobile is stolen by the petitioner, but the kept mobile is not recovered from the petitioner.
One mobile phone that is
Yes. Yes, that mobile is not the petitioner.
Who was arrested first? You were arrested.
I am the arrested.
The petitioner is an accused for allegedly committing an offence punishable under section 414 of the 34 of the Indian Penal Code. Next paragraph. From the impugned order, I find that how the concept for the parties. From the impugned order, I find that the petitioner was arrested on suspicion that the motorcycle which he was riding is stolen and he had intention to sell the same. Full stop. After the petitioner was arrested, a mobile phone was recovered from the possession of this petitioner. Full stop. Confession of the petitioner was extracted and he confessed that he and others stole several mobile and money from shop in Odisha, in Cuttack, Odisha. Next paragraph.
I'm inspector of no criminal incident.
We were in custody since
28/11/2000.
considering the fact that the petitioner is in custody since 28/11/2021 and charge sheet has already been submitted and the case is only under section 414 of the 34 of the Indian Penal Code, I am inclined to release this petitioner.
Case number 24, case number 2165 of 22, Mr. Sarvendra Kumar, for the petitioner.
Nothing has been covered from my position. My name has been disclosed by post conditioner of the approach being report.
Yes? Who is for the state? And the counsel for the petitioner, no one appears for the state.
Alleged offence under section stated that para 1 differs from impugned order.
Order there is some error. The police apprehended the petitioner is an accused for allegedly committing an offence under section so and so. The police apprehended one Dhananjay Kumar, who disclosed that he, along with these two petitioners, has stolen a motorcycle and kept it in the house of Chandan Kumar. That is petitioner number 2. The motorcycle was recovered from the house of petitioner number 2. Good stuff. Next paragraph. The petitioner is in custody since 8/1/2022. Full stop. Considering the fact that the case is under section 414 and 34 of the IPC, and considering the custody, I am inclined to release the petitioner 10,000 securities once a month before the trial court. Participants, APP opposes.
Serial number 25, PA number 2166 of 22.
86 pieces of vodka and 22 grams of food has been recovered from the apprehended person and then been granted by this honorable court also connected 2 and 3. No recovery from this petitioner. Name transferred on the basis of disclosure statement of Arjun Yadav. He has been granted by
Yes. Have the counsel for the petitioner, have the counsel for the state. The petitioner is an accused for allegedly committing an offence punishable under section so and so. 86 logs of wood and 22 pieces of what is this beam? Wood was recovered from a truck and Maruti vehicle. Full stop. Next para. Admittedly, the petitioner is not named.
Named in FIR.
You're not arrested from the place of occurrence.
No, Your Lordship.
Admittedly, the petitioner is not arrested from the place of occurrence. Also, similarly situated co-accused Upendra Udhar has been and Sanjit Kumar and Rishi Kumar has been granted bail. Chandrapal Hira Devli Annexure 2 series has been granted bail by coordinate benches of this court. The APP opposes but cannot dispute that similarly situated co-accused person has been granted bail. Also, considering the fact that co-accused has been granted bail and the petitioner was not arrested from the place of occurrence without appreciation.
Serial number 26, PA number 2167 of 22, Mr. Anurag Kashyap.
This is a petition for grant of regular case under section 321, 120 IPC. We will find from the FIR that there is no allegation of the assault against the petitioner. Petitioner is an old man, age of 69 years, but he was in the house. The informant says, my lord, that after hearing not the noise, rather not the cry of her husband, she had gone not to the house of this petitioner. This petitioner had not accompanied her, neither not he had gone at the place of her. And that's why not she has raised suspicion that not the one Manoj Singh, who is the son of this petitioner, had committed murder. Therefore, not this petitioner has also got the hand and he has given direction. That is happened from page 19 of the FIR. But that is the only allegation. Again, this not Manoj Singh has been granted bail by this court. Not against whom the allegation was that he had got it.
You have other cases against you.
Yes.
You have other cases against you.
Yes, only one case, Lord, that is not the 323, 353, and 34.
So why were you an absconder?
But the investigation was kept in that they have content not from paragraph 87 of the case diary. But the same thing,
What for the case diary? Case diary.
Number 27, number 2168 of 22, Mr. Sanjay Prasad for the petitioner.
Case to under section 392 IPC, the FIR against unknown, and nothing has been found from the possession of the petitioner. Rather, the associate motorcycle has been found from possession of Arjun Ansari and Islam Ansari. That is case number 14 of the imperial order. And they have been granted bail by the
You have a case under section 302 pending against you.
Yes, it's my lord.
Case diary, antecedent of the petitioner, full stop. The affidavit should be filed by the state intimating this court the nature of cases which are pending and the stage of cases which are pending against the petitioner.
Serial number 28, PA number 2169 of 22, Mr. Mohammed Ahmad.
Case is alleged that 2.5 gram brown sugar has been recovered from the petition of this case, which is much less than small quantity. It is alleged that altogether 6 kilos sugar handed and lordship from this petitioner 2.5 gram brown sugar is recovered, less than small quantity to maximum sentence in such situation is 6 months. And one co-accused, the Vishal Kumar Yadav has been granted bail. Petitioner is having no criminal activity.
Not now. 2.5 gram of brown sugar was recovered from the possession of this petitioner.
6 months or not.
Now, learned counsel for the petitioner submits that the punishment is only for 6 months. Full stop.
It says that no criminal
It says that the petitioner has got no criminal antecedents. And the co-accused has been granted bail. Considering the material which is brown sugar recovered from the possession of this petitioner, I am not inclined to grant bail to the petitioner at this stage.
DA number 29, DA number 2170 of 22, Mr. Manoj Kumar Saab for the petitioner.
Waiver. On the offense pursuant to 341, 354, 436 by 54 Act. But there is delay of another 64 days in filing the complaint. The allegation कि हमारे घर में कुछ आग लगा दिया, भागते हुए देखा गया है और हमारा लॉस and earlier 4 months back daughter of December
When was the complaint filed?
complaint filed on 19/9/2020 19/9/2020
Date of occurrence?
16/7
The case initially arises out of a complaint. ऊपर में लिख दीजिएगा, हाँ, as an accused. The case initially arises out of a complaint. There is an allegation this petitioner and others have burned the roof of the where what was damaged by fire?
Hello?
The roof.
Roof. Whose cover car?
The roof of the hut of the informant. First up. The learned counsel submits that earlier this petitioners,
Daughter of petitioner number 1 has lodged a case being Bodda Mufasi PS case number 62 of 2020 under section 376(1) of the IPC and 34 of the POCSO Act against the son of the informant. First up, he submits that the instant case is a retaliation of the aforesaid allegation. First up. Next paragraph. Considering the aforesaid fact and the fact that there are 2 months delay in lodging the complaint, which was registered under section 156, which was registered as an FIR, I am inclined to release this petitioner 10,000 petitioners 10,000 shekels.
Serial number 30, DA number 2171 of 22.
Authentication fee of rupees 10 is 1.
Authentication fee. Authentication fee is one thing.
It was 4 other defects.
Remove the defects within a week.
Serial number 31, DA number 2172 of 22. Mr. Suraj Singh, Mr. Suresh Singh.
Offences are under section 397 and 397 of IPC. Petitioner is not named in the first information report. Petitioner has been remanded in this case from another case, and there is no TIP in this case. The name of the petitioner has come on the basis of confidential statement of court persons. That time in custody.
The case started, the petitioner apprehended from the hands of police, and thereafter that motorcycle was recovered from his action.
Who was apprehended? This petitioner was apprehended.
Yes. And thereafter they said about the
Then
motorcycle.
that is a different case.
That is different case. Thereafter lodging.
In this case, only on the basis of the self-confession statement.
Yes, but motorcycle recovered from him also. And this is also
Custody.
Your time in custody since 7th of August 2021.
The counsel of the petitioner is an accused for allegedly committing an offence under section 7 next paragraph. The petitioner was arrested in which case?
Manika PS case number 74 of 2021.
74 of 2021. A motorcycle and country-made pistol was recovered from his possession. First up, the petitioner confessed his guilt and also confessed that he was involved in this case where there is an allegation that some unknown person snatched the motorcycle, mobile and 6,000 rupees from the informant after tying him to the tree. So next paragraph. The counsel for the petitioner submits that the petitioner was not put on TIP and charge sheet has already been submitted in this case. He submits that the petitioner is in custody since
7th of August 2021.
7th of August 2021. The APP opposes and submits that the motorcycle was recovered from the possession of this petitioner. But from the impugned order, but after going through the impugned order submits, there is nothing to suggest that the petitioner was ever put on TIP. She submits the charge sheet has already been submitted in this case. Considering the fact that charge sheet has been submitted and there is nothing to suggest that the petitioner was put on TIP, and here full stop, comma, I am inclined to release this petitioner on bail once a month before the trial court.
The measured amount is 9,000 rupees.
6,000 it has been made in the impugned order. 9,000.
It is an FIR, it is 9,000.
Yes, next.
Serial number 32, PA number 2174 of 22. Ms. Alka Kumari.
The Lordship, the allegation is that the section 304B and 3M were found in the petition act. Lordship,
Who are you?
I am the husband, Your Lordship. Lordship, it is stated that after marriage that I subjected my wife to torture, Your Lordship, but no complaint case whatsoever was ever referred to.
Case diary.
Serial number 33, PA number 2175 of 22.
Lordship, the allegation is under section 376, 506 of IPC. Lordship, the occurrences of 7/10/2021, whereas the FIR was lodged on 12/10/2021. Then when she was examined, victim was examined by the doctor on 13/10. No sign of injury or struggle mark was found, Lordship. The victim is 45 years old lady who is married and even have children.
Call for the LCR, call for the case diary. So the trial court is directed to send a copy of the statement of the victim recorded under section 164 CRPC.
Serial number 34, PA number 2176 of 22.
This matter was considered under section 323, 341, 342, 379, 376 and 504 and 506 of the IPC. Allegedly, they both were into a relationship for almost last 3 years, Your Lordship. And the petitioner in this case is under the allegation that he promised to marry her, Your Lordship.
What is the age of the girl?
Age is 22 years, Your Lordship. It is a part of the FIR, it's on page number 15. Her date of page number 14. Her date of birth is 3/2/2000.
Age of the girl is
3/2/2000, almost 22 years. Page number 14 is the Jharkhand National Council admission card.
3/2/2020.
Okay. I've also mentioned in paragraph
And the
number.
petitioner is an accused for allegedly committing an offence punishable under section 12. So next paragraph. There is an allegation that this petitioner has committed rape upon the victim on the pretext of marriage. So next paragraph. From the impugned order and the FIR and the documents, I find that the girl is aged about 20 years. Aged about 20 years and thus is a major. They were having some 20-22 years. And thus they were having some relationships since last 4 to 5 years, and the girl was assured that the petitioner will marry her. First, upon this assurance, the physical relationship was established, and thereafter it is alleged that the petitioner refused to marry. Next paragraph. From the aforesaid allegation, next paragraph. This aforesaid, this is the victim is a major, and she knew the effect and the consequences of a physical relationship, and entered into same with the petitioner, though on the pretext of marriage. First up, the petitioner is in custody since
14/9/2021. Charge sheet has been submitted.
14/9/2021, and charge sheet has already been submitted.
15/12/2021.
Thus, I am inclined to release the petitioner on 10,000 to sureties.
Serial number 35, PA number 2178 of 22.
Offense under section 392 is not named in the FIR. The FIR registered against CM. The name of the petitioner has transpired in their self-confession statement. No, they are in custody since 19/11/2021, but till date no TIP has been made. Charges had already been submitted.
Yes. Huh?
1 kilo plus for you, from the forest kilos. From the confidential statement of this petitioner, thereafter condition that there is recovery one duplicate pistol and one prepaid
Duplicate pistol. The petitioner is an accused for allegedly committing an offence under section so and so. It is alleged that some two unknown person on 16/11/2021 assaulted the informant and looted away 6,100 cash and a mobile phone. From the informant, and one cell phone from Kamlesh Garji. The miscreants had covered their face, so they could not be identified. Next part, the petitioner were arrested and they confessed their guilt. Full stop. For the possession of this petitioner, one keypad of Samsung mobile and one duplicate pistol was maybe a toy pistol. A duplicate pistol was recovered. Full stop. Counsel for the petitioner submit that charge sheet has already been submitted in this case and cognizance has also been taken, but surprisingly the petitioner was not put on TIP. The petitioner is in custody since 19/11/2021. Considering the fact that the petitioner was not put on TIP and charge sheet has already been submitted and the period of custody, I am inclined to release the petitioner subject to the condition appear before trial court once a month.
Serial number 36, PA number 2181 of 22, Mr. Shiv Kumar Singh for the petitioner.
In this case, trial court has filed. Regarding defect number 2 also, the signature of the deponent, the spelling is mistake.
You are the husband?
Lots of husband case under section 304B, but charge is
CD.
submitted.
CD postmortem.
Serial number 37, PA number 2182 of 22, Mr. Anjali Kumar.
Alright.
Case diary antecedent.
Serial number 38, DA number 2183 of 22, Mr. Rakesh Kumar.
As per the report of District Computer Section, the petitioner has reviewed the ADA number 3828 of 21, which is closed up, is not mentioned in paragraph. There's one more delay.
2 weeks.
Serial number 39, DA number 2184 of 22, Mr. Sundar Majumdar.
But he has not been TI, but he was, his name came up on official statement. Only because we have a go down in which where 2 batteries were recovered where it was not put on TI corridors. On that basis, 412 was
Custody.
Custody is 23rd December 2021.
Yes. Yes.
But not, it has come that
Yes.
article was recovered from the godown of this petitioner. Your and temple was also received. That was belongs to the petitioner.
Not even a week you have filed this.
Everything is coming within 2-3 days.
Not even a week you have filed this application. And you are getting an order today.
Our is like earlier days were very filed.
This will not continue forever. Because all are defective cases. We are keeping our eyes closed with the Jharkhand High Court rules. After Holi now you all have to come through the regular course.
The physical rule is better.
No, regular course means this all the defect removal. Have the counsel for the petitioner, have the counsel for the state. The other senior counsel submits that the petitioner is not named in the FIR and there is nothing to implicate this petitioner in this case. To relate, there is no material to implicate this petitioner. He submits that just because the petitioners have a battery shop and 2 batteries were recovered from the same shop, the petitioner has been made an accused. Next paragraph. The APP submits that some miscreants looted 20 numbers of live batteries and some dead batteries worth rupees and cash of rupees 2,200 from the control room of
Jamadova.
Jamadova what? The control room of Jamadova Electric Office. Full stop. The APP submits that the value of the stolen material is 1,50,000. Now approximately 1,50,000. Next paragraph. Considering the fact that the petitioner is not named and not put on TIP and as per his statement that there is no criminal antecedent, I am inclined to release the petitioner 10,000 sureties with a condition he will appear once a month before the trial court.
Under section and FIR and include order differs.
76, 400, I wanted for.
Age of the victim.
22.
Also,
about 16.
16 years.
Yes.
Call for the case diary. Post of the trial court. The court below is directed to forward a copy of the statement of the victim recorded under 164 CRPC.
Serial number 41, PA number 2186 of 22, Mr. Vinod Kumar Jha.
Under section 392 of the Indian Constitution, nothing has to be covered now. But it is the hearing courts in order to seven and charge sheet has already been submitted in this case below.
What has been looted?
And it is alleged on both persons below has submitted a sum of rupees 1,64,000 to the manager of the cash flow India. But not to discuss what them to the FIR, nothing.
What is your antecedent?
Malak, it is alleged on the one antecedent on the 379 case. He remanded with this case.
Is it custody since?
Custody since 12/7/2021.
The petitioner is an accused for allegedly committing an offence of this punishable under section so and so. Next paragraph. Counsel for the petitioner submits that he was not put on TIP.
TIP पहले जो पहचान की गई है।
पहचान की गई है?
जी, सिर्फ नाम मंगा दिया जाए। पेज नंबर 21 है।
कहाँ दिखाइए?
पेज नंबर 21।
मतलब 21
लास्ट के नीचे में सूचक द्वारा आवेदन की परेड में पहचान की गई है।
What allegation? He has been identified not now. The petitioner is an accused for allegedly committing an offence under section so and so. From the imputed order, I find that the petitioner has been identified in the TI parade as a miscreant. Full stop. Considering the fact that the petitioner was identified in the TI parade, at this stage I am not inclined to grant way to the petitioner. The same is rejected. The petitioner, if so advised, may renew his prayer after the informant is examined during trial.
Serial number 42, PA number 2187 of 22, Mr. Rahul Ranjan.
It's back on when was already new representation of.
नहीं अरे हमारा गाँव दूसरा जगह है सूरजपुर में गाँव नहीं है क्या सवाल करते हैं
Whose informant and the victim are of the same place?
है इसमें
हाँ, informant and the victim is from the same place. Then किस गाँव का है? What are you trying to say? So what sort of submission is this? What sort of submission is this? Tomorrow you will say that this court is from Jharkhand, so I will not hear any cases from Jharkhand. What sort of obnoxious submission is this? Mind yourself, Mr. Counsel. From the next time, don't try to make this type of submission. Such a casual, irresponsible statement. Case diary? Yes. And the antecedent report?
Under the heading of fresh filing, serial number 43, PA number 2133 of 22.
Section 147 148, 149 07 of the IPC and 57 of the Arms Act laws. For the petitioner is not named the FIR laws and does the common the confessional statement of laws. Surendra Yadav also the name of petitioner has come also. And also the charge sheet has been submitted, cognizance has also been taken, and also the petitioner is in custody since 4/10/2021.
What happened to the other co-accused?
In another lawsuit, tomorrow tomorrow you listed one case loss.
Other one?
And lawsuit by information also. Another lawsuit they named in the FIR lawsuit. Here the city was called.
Number?
Yes.
Case number? Maybe CD was called for.
कल ही शुरू हुआ है।
I know it. When will you go? Then discuss along with so and so whether the case diary has been called for.
लेकिन इसके अगेंस्ट nothing given at mobile logs at the date of offense logs. Except confession logs, nothing has been.
Let us see the case diary.
एलिगेशन है वो कि
217 of 2021, Jayanagar, Kodalba. Check out. Pass over. Find out. Yeah, what is this?
Four cases have been filed on the same FIR.
Hmm?
Total 4 cases have been filed on the same FIR. Let's just find out which
Yes.
case.
DA number 44, DA number 2136 of 22, Mr. Pran Pranay.
Two lawsuits, the FIR has been filed as 13 named accused person, and informant is the eyewitness of the case lawsuit. And specifically alleged in the first information report that one Babu Mani Yadav, Vakil Yadav, and Tutu Yadav have fired upon brother of the informant. And lordship, the Vakil Yadav has also been granted bail, lordship. That is case 21.
How many witnesses left?
Lordship. And that count, that bail has been done. Lordship, the 18 witness, altogether 18 witness, and in which lordship 6 witnesses have been examined. On this ground, the bail has been granted. 3 times rejected, lordship, case 21.
There is a consistent threat up to the witnesses.
No, lordship, I am not present at the place of and specifically.
I am not on merits.
My name has come on the basis of confessional statement of Kamal Yadav, lordship. That is only there, lordship. And all the accused person, almost 6 or 7% have been granted bail, lordship. Even maybe accused person have been granted.
Maybe.
All the accused
Yes.
person, even maybe.
The AVP is directed to file an affidavit. The state is directed to file an affidavit stating the threat perception upon the witnesses by the accused of this case, as in the impugned order it has been recorded by the additional session judge 6 Devghar that during course of recording of evidence he was apprised that there is a constant threat to the witnesses of this case.
That is not against me.
Not against you or anyone, if in a particular case a threat is given.
No, I am in custody since 2000.
DA number 45, DA number 2141 of 22, Mr. Vishal Kumar Tiwari for the petitioner.
Lordship, in this case I am appearing on behalf of the petitioner. The petitioner has been in custody from 21st March 2020. The petitioner is an ordinary farmer and he has nothing to do with the Life group. Also, there is no criminal antecedent against this petitioner, which has been specified in para 8 of the petition. Also, Your Lordship, there is no specific allegation against this petitioner and no overt act has been attributed to him, except that he was part of the outlaw group. So, in light of that, I am saying for you.
Case diary.
DA number 46, DA number 2145 of 22, Mr. Manoj Kumar number 2.
they are jurisdiction. Second one is multiple answer jurisdiction. Both are identical. Time, place, time, date, information, mobile number, immediate, both are. And on that case, one will be the
The phone belongs to whom? The mobile phone belongs to whom? This number?
My lord, belongs to petitioner, my lord. Therefore, I support the petitioner has not been my lord.
Case diary.
Serial number 47, BA number 215022.
This is the section 304B of the
Case diary.
Serial number 48, BA number 215122.
What is the material, Mr. Ojambal?
460 milligram of grams.
460 milligram of brown sugar was recovered from the possession of this petitioner. Next paragraph. Considering the nature of recovery, the material, I am not inclined to grant bail to the petitioner. Dismissed. No stage.
Like this.
No stage.
No, like this साइड में एक बात सुन रहे हैं हम इसीलिए बोले जब दिल्ली का कोर्ट में केस आया we know your lordship your video is saying that his father's I still told his father कि तुम्हारा क्या इसमें बिल नहीं होता है इससे भी कहा कल से रोने लगा अभी कोर्ट नंबर 4 में भी रो रहे हैं
So at least you can give guarantee in one case. Yes.
Serial number 49, BA number 2153 of 22. Mr. Abhi Shankar for the petitioner.
The case registered under section 379 of the Indian Penal Code. The motorcycle of the informant was stolen. Now, during investigation, the said motorcycle was seized in connection with Kerala PS case number 92 of 21 from the house of one who accused Dev Narayan Saw. The said motorcycle has been seized in connection with.
And he confessed that you are the person who has helped him to get the motorcycle.
These three persons were the petitioner is also an accused in Kerala case 92 along with the other persons from the house of Dev Narayan Saw, the said motorcycle.
You have the counsel for the petitioner, have the counsel for the state. The motorcycle of the informant got stolen. Full stop. During investigation of Kedari PS case, 92 of 21, when Devnarayan Saw was arrested and motorcycle was recovered from his possession. First up, he confessed that he and his other associates have committed theft of motorcycle. He confessed that they have stolen 14 to 15 motorcycle and this petitioner had facilitated them in selling the motorcycle. Next paragraph. From the aforesaid fact, it is clear that the petitioner's name transpired from the confessional statement of the co-accused. The petitioner is in custody since 29/11/2021 and charge sheet has already been submitted in this case. Definitely. Considering the fact that the period of custody and the fact that charge sheet has been submitted and the name of the petitioner transpired from the confessional statement of the co-accused, the petition is directed to be released. You don't have to see more than 3 months.
Yes.
So,
Serial number 50, BA number 2156 of 22. Mr. Videsh Kumar.
What is going to be granted by your lordship connection to page number 23?
to page number 23.
Page number 23.
You are an absconder.
No.
Then, why are you moving now? Because bail was granted in 2017-18.
It's taking more than 4.5 years.
4.5 years?
4.5 years, 5 years. I have shifted in
28/6/17. You have not moved earlier.
No, Your Worship.
How many witnesses left?
3 witnesses examined out of 9 witnesses.
The petitioner is an accused for allegedly committing an offence under section so and so. So he is in custody since 28/6/2017. And only till date 3 witnesses have been examined.
Yes.
The APP opposes the prayer but cannot dispute the fact that similarly situated co-accused has been granted bail.
Yeah, we do not see from the inclusive factors that the petitioner has criminal liability.
Maybe. But you have kept him in custody for so long and you have not concluded the trial. Refer to Annex 2. Considering the period of custody and the trial will not be concluded at the earliest and the other 2 accused has been granted bail, I am inclined to release the petitioner once a month before court. Passport.
Passport matter, serial number 43, BA number 2133 of 22.
Clear.
Yes, BA number 2039 of 22.
List this case along with BA number 2039 of 2022, in which case diary has been called for.
In my case, who should certify to be ignored?
Let me see which defects are to be ignored.
1 and 2. Defect number 1 and 2.
The rest you have removed?
The type of case filed by tomorrow, but so much other things
What?
ये टिकट ये है जो कि कंप्लेंट पिटीशन लिख दिया SC/ST पॉक्सो केस नंबर और रिव्यू ऑर्डर में लिख दिया है SC/ST कंप्लेंट के दैट इज वन से पॉक्सो केस नंबर पॉक्सो वर्ड मेंशन नहीं किया है और एक ये हो रहा है कि जो हम प्रोसिक्यूशन केस है इसका बेल कॉपी दिए हैं उसमें लास्ट में स्टैंपिंग नहीं दिए तो सर्टिफाइड कॉपी लगाए इसमें स्टैंपिंग आया नहीं तो बात
Defect number 1 and 2 is ignored for the present. So far as typed copy is concerned, the counsel for the petitioner undertakes to file it by a week, within a week. The rest of the defects he submits that he has already removed.
So in serial number 43, CPM injury report has been filed. The same case, last week. Along with.
Just write along with in which CD has been